Session 11 of the series on military law pertains to conditions of service. Now, the conditions of service are those rules which lay down the conditions of employment, and therefore it is only logical that employee must know what his service would be governed by necessary conditions laid down under the law and the statutory rules. These need to be clearly known to all ranks and file of the army. These conditions of service pertain to initial appointment or induction, thereafter promotion in a pyramidal force like army from one rank to another, the award of substantive ranks which are confirmed, how the seniority of persons would be determined, because the inter se seniority results into power of command and establishes a relationship of senior and junior. What are the rules regarding grant of acting rank, performance appraisal by way of rendition of confidential reports, movement of persons from one place to another, which is commonly covered under transfer postings? What are the necessary and mandatory promotion examinations that have a bearing on upward elevation in the structure and the grant of leave? All these matters are covered under conditions of service. However, it appears little strange that the Army Act and the rules do not speak out on majority of these issues, although there is a distinct chapter under the Army Act. It is under the title Commission, Appointment and Enrollment and Conditions of Service, but some of these aspects that were there in the earlier slide have not been given definition or the rules, or they have not been given place under the Army Act and the rules. There are few provisions of defense services regulations for the army devoted to some of these aspects, but since regulations for the army are non-regulatory in nature and therefore they do not have the requisite potency or they do not carry the desired weight. And this has led to a number of court cases which have been decided. A certain policy has been laid down, but a large number of cases are still pending and they continue to come up before the courts of law. In the matter of Colonel A.S. Sangwan, it was laid down that Union of India can change policy formulated earlier. It is within the domain of Government of India to change the policy. However, the court made it clear that the new policy which has been formed must conform to the requirement of equality. Further, it should not give an impression that it is acting by any ulterior motive or acting in an arbitrary fashion. It's also desirable, in fact, it is mandatory that the new policy laid down must be transparent and it must be promulgated and made known to all those who are affected by it. And it should be done in a fair manner. The other matter is of Air Marshal Amarjeet Singh Sethi, wherein Karnataka High Court laid down that Section 191 of the Air Force Act mandates that all rules and regulations made under the Air Force Act are required to be published in the official gazette. It is only their notification, publication and notification in the official gazette, that it can be taken that the rules have been duly publicized and they have come to the notice, and all ranks are aware of the new policy that has been changed. And it is the action of publication in the official gazette that brings out a situation as if the rules have been enacted under the act. Now, the court, the decision in this matter brought out that power to frame rules or regulations does not necessarily imply that no action can be taken administratively in regard to a subject matter in which rules or regulations can be framed until it is so framed. In other words, even when rule making is in the pipeline, or the rules have been framed but have not been published, they do not stop the government from proceeding on that policy as long as requisite action has been taken to make them known to whatever are the persons who are going to be governed by those rules, so that in case they have any grievances and they think that the rules have not been correctly acted upon, they can set forth their grievances. The conditions of service which are there codified under the Act carry certain service privileges. Now, these service privileges are the benefits which are enjoyed by the service personnel, and naturally it is in their relation to civil courts and the law administered by those courts. They are conferred, these service privileges have been indicated and enumerated under the acts framed by the Parliament, and these were designed during the British days to ensure that there is a total and uninterrupted involvement of military for their functional efficiency, and the military personnel are not put to unnecessary hardship and delay because of rules which were there in the courts or framed, uh, made known by the administration. Now, therefore, these rules which come under the heading of service privileges have come from the British days to the Army Act that was framed in 1950, and they start with Army Act Section 25, which says that authorized deductions only to be made from pay. You would recall that during the days of the East India Company, there were feudal lords, subedars, who used to bring the soldiers who were their followers into the British Army, and it is these feudal lords who used to distribute salary, and at times they used to keep their portion or their commission, which was not given to the individuals. Now, to combat such a situation, the law relating to authorized deductions only from the pay was made, and it is continuing. Section 25 as it exists now says that pay of every person subject to this act due to him as such under any regulation for the time being in force shall be paid without any deduction other than the deductions authorized by or under any other act. This indicates that firstly there should be regulations that govern what would be the pay and allowances, and the amount which is indicated under those regulations shall be paid without any deduction, except those deductions which themselves have been indicated or enshrined under the law. So in this manner, it has been ensured by law that only authorized deductions can be made from the pay, and something which is unofficial or unauthorized, there is no scope for such a deduction from the salary. Moving next, section 26 pertains to remedy of aggrieved persons other than officers. So there are two provisions. One, 26 relates to persons below officer rank, and the next 27 deals with the officer rank. What does it say? Clause 1 says person subject to this act other than an officer, if he carries an impression that he has been wronged or he has a grievance from any superior or other officer. Now, if he is not attached to a troop or company, will complain to his commanding officer under whom he is serving, and if he is attached to, forms part of a troop or company, complain to officer commanding of the same. So, say a person is unhappy with the decision of his section commander, then he will go to the platoon commander or company commander and complain to him, which is his right and which affords him an opportunity to seek a remedy. So, clause 2 says when the officer complained against is the officer to whom any complaint should under subsection 1 be made, aggrieved officer may complain to such officer's next superior officer. This makes it clear that if the officer who is to be approached for grant of remedy is the one actually against whom there is a problem, in that case there can be a jump and the next superior can be approached for seeking of redressal of grievances. Now, there is a duty cast on the officer who has received such a complaint. He is expected to make as complete an investigation into it as may be possible for giving full redress to the complainant, or when necessary refer the complaint to superior authority. So there are three situations that can be there. Number one, the first thing which is common to all the three situations is that make as complete an investigation. In other words, carry out a thorough investigation, inquiry into the matter. If the person concerned deserves a relief, will give him the relief if it is in your power. If you cannot give relief, then, or if you are in doubt, refer the matter to the superior authority that will you kindly take action into this. Next clause says that such complaints will be forwarded and preferred made in such manner which will be laid down by the proper authority. That what would it state, where you will state the grounds, the actual prayer, the effects and circumstances of the case. Now, the mode of making a complaint may be laid from time to time by the proper authorities so that that manner is complied with in projecting the complaint. The next clause says central government may revise any decision by the Chief of Army Staff under subsection 2, but subject thereto the decision of Chief of Army Staff shall be final. By this clause 5, it has been inserted that in such a complaint by a person other than an officer, the Chief of Army Staff will be the final authority. However, when so required, the decision of Chief can be changed by the central government. So this is a very visible and potent remedy provided for redressal of grievances. Next, section 27 comes to officer, and in the case of officer, it is being laid down that an officer who deems himself wrong by either his commanding officer or any superior officer, and who on due application made to his commanding officer does not get the redress to which he considers himself entitled, may complain to the central government in such manner and may from time to time be specified by the proper authority. Put it more simply, it indicates that if there is an officer who feels that he has been wronged by his commanding officer, or anybody superior to the commanding officer, must reach out to the commanding or such a superior officer, and having approached that person, if the officer, the complainant, still doesn't get the relief, the remedy, the solution which he feels he is entitled to, then he is law bound, or he has power, a right under the law to reach out to the central government in the manner breaching out the manner would be laid down, like in the case of persons below officer rank, as to how the complaint shall be made. Next, section 28 under the Army Act pertains to attachment. Now, this says that anything which is necessary for a soldier, and soldier word is wide, it includes everyone, for due effective performance of his duty cannot be attached by any civil or revenue court. So the wordings are neither the arms, clothes, equipment, accoutrements, or necessaries of any person subject to this act, nor any animal used by him. In the earlier days, soldiers had their own horses. So, nor any animal used by him for the discharge of his duty shall be seized, nor shall the pay and allowances of any such person or any part thereof be attached by direction of any civil or revenue court or any revenue officer in satisfaction of any decree or order enforceable against him. Just to illustrate, say a soldier has a plot of land in his village and for which the revenue has not been paid, the taxes and the duty has not been paid. Now, no revenue officer or court can say that for the default this soldier has made in depositing the land revenue or the rent, this much portion shall be attached from his salary, or maybe his rifle will be taken away, or his horse or pony will be taken away. Well, that cannot be done because of verdicts of section 28. So, in satisfaction of any civil or revenue process, the belongings, including the pay and allowances of a soldier, cannot be attached even if so ordered by a civil court or a revenue official. Now, this is a big service privilege that has been given to the soldiers. Next clause is applicable in relation to debt. The earlier one was for a revenue process. Here it says, no person subject to this act shall, as long as he belongs to the forces, be liable to be arrested for debt under any process issued by or authority of any civil or revenue court or revenue officer. So if there is a revenue court or a civil officer, civil court, which says that for the satisfaction and realization of debt, arrest the soldier, well, that action cannot be taken because of section 29 of the Army Act. Further, section 29 states the judge of any such court or the said officer, which is in relation to court officer or a revenue officer, may examine into any complaint made by such person or his superior officer of the arrest of such person contrary to the provisions of this section, and may by warrant under his hand discharge the person and award reasonable cost to the complainant, who may recover those costs in like manner as he might have recovered such costs awarded to him by a decree against the person obtaining the process. Now, the wording of this clause 2 makes it clear that in the situation that a person has been arrested for realization of a debt, then the person concerned is expected to make a complaint to the judge or that court or that officer, and immediately that court or the judge or the officer shall, by warrant under his hand, order the discharge of that person and ensure that he is not continued to be retained in custody. And further, it may award him reasonable costs also, which will be duly recovered like they are there for any revenue process. And lastly, it has been laid down that for making such recovery of such costs, the person concerned who is aggrieved, who had been arrested, shall not be called upon to pay any court fee. Further, section 30 comes into play when there is a court martial taking place and the persons who are necessary for the proceedings of that court, they are immune from arrest. Now, who are the persons who are associated with a court martial? Obviously, starting from top, the presiding officer or members of the court martial. If it's a summary court martial, the presiding officer, and in case of other court martials, the presiding officer as well as members. Then there is a judge advocate, the party to the proceedings before a court martial, their lawyer or agent, or a witness who's required to go and appear before the court martial in response to a summon, while they are going to or in the process of attending or returning from a court martial, they cannot be arrested in response or following a civil or revenue process. Now, therefore, it is to be appreciated that firstly, this protection or this privilege is only with regard to a civil or revenue process. It is not available with regard to a criminal matter. All the persons, category of persons who are associated with that court martial, they are immune, and they are immune, so immune, while the court martial is in process or when they are going to attend a court martial, it is yet to start, or they are returning from there. And in case if any such person due to any reason is arrested, then the court martial has been authorized under clause 2 to order that such a person should be released because of the order which is given under the seal of hand and seal of that court martial. Next section is reservists. The earlier provisions were for the persons who are in active service. Now there are also reservists who have gone home and they are required to, they can be called upon and they are required to appear when called upon for active service. Now this section 31 is in relation to those persons who are reservists, and it says that every person belonging to Indian Reserve Forces shall, when called out for or engaged in or returning from, like court martial, these reservists, when they have been called out, they are going for military service or they are engaged in military service, or on the expiry of military service when they are coming back, or during training or service, they will be entitled to all the privileges which were there under section 28, 29 to a person subject to this act. So they would be treated likewise. Now, there are a couple of decisions I would like to highlight. Firstly, there is Babu Jagmohan Lal's case versus Gomti, which is of Allahabad High Court in 1933. In that situation, an accountant in the army was employed in field area, and he was said and he was called upon that his salary would be attached because of some revenue or civil process, and the High Court held that he is exempted from attachment of his salary till he continues to be so employed as part of the army. The other matter is of Gyan Chandar versus Mehar Singh, where it was ordered that attachment of portion of pay which had been set aside towards a security, the court held that, well, as part of security, his salary which has been withheld or set aside, that action is invalid. Pay and allowances of army persons are fully protected and they cannot be attached just because security is to be given. And in relation to section 29, there is the decision of Lieutenant Kumar Chitraketu Singh versus State of Uttar Pradesh, where the court had held that person appointed to the honorary rank of second lieutenant in the regular army is entitled to immunity from arrest for debt as long as he belongs to army in that capacity. Now, the Chitraketu Singh, as a second lieutenant, which was given to him as an honorary rank, as long as he held that rank, he was entitled to immunity, and this immunity is only from arrest and not from recovery of dues towards land revenue. So the court made it clear that, well, you can't arrest him, however, he would be required to pay the dues towards the land revenue. Now, a study of these service privileges which have been inserted in Army Act would indicate that codified law on various aspects of conditions of service, uh, by their incorporation and giving place in the statutory law, it facilitates consistent and transparent application of rules from examining their reasonability, and it is for the military law experts that they remain aware and sensitive to these provisions so that they can be duly applied. Due promulgation of service privileges is also necessary so that the service personnel, they know that they have vested in them these privileges which are of a statutory nature. Thank you.